In November 2025, the UK will enter one of the toughest immigration eras in its history. Thousands could face sudden deportation, not just criminals, but also overstayers, failed asylum seekers, and those breaking visa rules. New policies aim to tighten every loophole, making even small mistakes costly. The Home Office is redefining who deserves to stay and who must leave. Whether you've built a life, a family, or a future here, these rules could change everything overnight. This isn't a rumour or a warning. It's a reality unfolding right now across the United Kingdom. Number 10. Those convicted of sexual or violent offences regardless of sentence length. From November 2025, the UK government will begin enforcing automatic deportation for non-UK nationals convicted of sexual or violent crimes, no matter how short their sentence is. This reform closes a loophole that previously allowed offenders with minor or suspended sentences to remain in the country after conviction. The Home Office has made public safety its top priority, arguing that anyone who endangers others forfeits the privilege of living in Britain. Crimes such as assault, harassment, domestic abuse, sexual misconduct, or exploitation will all fall under this category. Even those receiving community orders or conditional discharges will be subject to immediate deportation proceedings once a guilty verdict is reached. The government believes this zero leniency approach will restore public confidence and reduce repeat offences committed by foreign nationals. Police forces and immigration officers will now work together more closely, ensuring swift coordination between criminal courts and deportation units. Officials claim this reform is about protecting communities and victims rather than punishing offenders twice. They argue that once someone is found guilty of a violent or sexual act, their right to remain becomes a national security concern. The process will be largely automatic, with limited grounds for appeal. Human rights advocates and legal experts have raised concerns that this may remove proportionality from the system, as even first-time offenders or individuals with mitigating circumstances could be deported. However, ministers insist that only those convicted of clear criminal acts will be affected, and that due process will still apply during sentencing. The deportation orders will be prioritised through fast-track channels, meaning removal could occur within weeks of conviction. This marks one of the most uncompromising changes in the entire 2025 policy package. For foreign residents, this signals an urgent need for awareness and personal responsibility. The UK government is drawing a firm line. Any offence involving violence, harassment, or sexual harm will result in removal, regardless of rehabilitation or residency history. Those already on probation or community service should remain compliant with all legal obligations to avoid triggering deportation. Community groups and legal advisors urge migrants to understand the gravity of this reform and its long-term consequences. The UK intends to make its stance unmistakable. Public safety will always outweigh immigration leniency. Number 9. Family members who fail to meet new private life or family visa rules. Under the updated 2025 immigration reforms, foreign family members or partners of UK residents who fail to meet the new family or private life visa conditions will face increased deportation risks. The Home Office has revised the financial, relationship and residency requirements for spouses, dependents and long-term partners living in the UK. Those unable to prove genuine relationships, consistent financial stability or continuous cohabitation could see their visas curtailed or denied renewal. The policy emphasises authenticity and transparency, focusing on identifying cases of marriage fraud, fake sponsorships or dependency abuse. Applicants must now provide more frequent proof of joint residence, communication and shared responsibilities. If the relationship ends, whether by separation or divorce, the non-UK partner may lose their right to remain, even if they have lived in Britain for several years. This rule aims to ensure that immigration privileges are granted only to families built on genuine, verifiable foundations. Officials say the measure is meant to protect the integrity of the UK's family migration system. Under the old framework, many individuals exploited loopholes by claiming relationships of convenience or using dependent routes to extend their stay unlawfully. The reformed policy demands stronger documentation, including joint financial records, tenancy agreements, and proof of emotional commitment. Sponsors who fail to meet income thresholds or dependents who fail the residency duration criteria may also face removal. Human rights groups, however, argue that the stricter standards could separate real families, especially those facing financial hardship or cultural barriers that limit formal documentation. They warn that these rules may disproportionately affect low-income households or families struggling during the cost of living crisis. Despite opposition, the Home Office insists that exceptions will only apply in rare humanitarian cases and that the new measures will prevent systemic misuse. For families currently living under the UK immigration system, the key is to maintain continuous legal compliance and relationship evidence. Keep all official records updated, including bank statements, council documents, and communication logs. If your visa renewal is approaching, consult an immigration advisor early to prepare accurate documentation. Any delay, error, or missing evidence could trigger visa cancellation and potential deportation. The 2025 changes redefine the meaning of family-based residence. Only those who can clearly demonstrate genuine, stable, and lawful family life will be allowed to remain in the United Kingdom. Number 8. Non-compliance with conditions of leave, work or study rules. From November 2025, the UK government will begin deporting individuals who fail to comply with the conditions of their visa or leave to remain. This includes those on student, work, or dependent visas who break specific terms attached to their status. Examples include working more hours than permitted, enrolling in unapproved institutions, switching jobs without authorization, or failing to maintain full-time study. These actions will now be treated as immigration breaches with direct deportation consequences. Previously, such cases often resulted in visa curtailment or warnings, but under the new enforcement system, the Home Office will treat non-compliance as a breach of trust, warranting removal. Employers, universities, and sponsors are being instructed to report violations more actively through an integrated immigration monitoring network. This network allows real-time data sharing between the Home Office, educational bodies, and workplaces, ensuring that any irregular activity triggers an investigation almost immediately. The government's goal is to maintain the integrity of the visa sponsorship system, ensuring that only compliant individuals continue to benefit from UK residency. The reforms also aim to prevent economic abuse of student or skilled worker routes, where some individuals use these pathways as cover for unauthorized employment or residency. Sponsors who fail to report violations may lose their license, which could result in hundreds of students or workers being removed at once. Officials say this rule will create a more transparent and accountable immigration framework, aligning every visa holder's stay with genuine purpose and lawful conduct. Critics, however, argue that such strict monitoring may unfairly penalise people for minor administrative errors or technical oversights, like delayed reporting or missed documentation updates. Despite that, the Home Office insists the policy targets only intentional violators, not genuine students or professionals. For anyone currently living in the UK under a sponsored visa, the priority should be full compliance with every stated condition. Review your visa terms carefully. Confirm that your work hours, study attendance, and sponsor details are always up to date, and keep documented proof of lawful activity. Small mistakes can now escalate quickly under the 2025 enforcement model. The government's message is clear. If you're in the UK on conditional leave, your residency depends on strict obedience to the rules you agreed upon when entering the country. Number 7. Those detained in immigration removal centres for long periods. People currently held in immigration removal centres will experience major changes under the November 2025 deportation policies. The UK government has stated that long-term detention without resolution will no longer be tolerated. Previously, many individuals were kept in detention for extended periods while their legal cases or deportation logistics were processed. Now, new rules aim to accelerate deportations by shortening detention times and making case decisions faster. The policy introduces a maximum detention review period, meaning each detainee's case must reach a clear outcome, either removal or release within a fixed time frame. The goal is to stop people from remaining in custody indefinitely while waiting for appeal results or paperwork from foreign governments. Immigration enforcement officers have been instructed to prioritise older, unresolved cases to free up capacity and improve system efficiency. For detainees, this means outcomes will arrive sooner, but it also means deportations may occur before secondary appeals are filed. The Home Office defends the move as a step toward restoring fairness and efficiency, arguing that prolonged detention is both costly and inhumane. Officials claim that most detainees already have no valid right to stay in the country, and that delays only increase public spending and administrative strain. Human rights advocates, however, are concerned that faster timelines may reduce access to legal aid and appeal opportunities. Many detainees rely on overworked lawyers who need time to gather evidence or secure documentation. If deportations happen too quickly, individuals could be sent to countries where they face real danger or hardship. The government maintains that safeguards will remain in place to protect vulnerable people and that detention reviews will still consider humanitarian circumstances. Nonetheless, the shift represents one of the biggest procedural changes in UK immigration enforcement since 2014. For detainees, understanding these changes is essential. Anyone currently in an immigration centre should stay in contact with their solicitor and respond promptly to all correspondence from the Home Office. Missing a review date or failing to update address information could now trigger immediate deportation. Families and community groups are urged to stay informed and offer support during this transition. The 2025 reforms signify a tougher, time-bound approach. Detention will no longer mean delay, it will mean decision. The UK's immigration system is moving toward faster, more decisive removals with less room for appeals. Number 6. Repeat immigration offenders. Under the November 2025 immigration reforms, individuals who repeatedly commit immigration-related offences will face automatic deportation and longer re-entry bans. This includes offences such as using false documents, working illegally, facilitating unlawful entry, or breaching visa conditions more than once. The government's stance is that repeat offenders exploit loopholes that weaken public trust in the immigration system. By introducing tougher penalties, the Home Office intends to ensure that anyone who consistently violates immigration laws faces swift removal. The new approach treats repeated offences as a pattern of deliberate misconduct rather than isolated mistakes. Even those who previously received warnings or temporary reprieves could now be prioritised for deportation. Immigration enforcement teams are being given expanded digital powers to trace offenders through national databases, employment records, and housing checks, meaning the likelihood of detection is now significantly higher than before. Officials argue this policy will help reduce illegal employment, identity fraud, and visa abuse, which have long been challenges within the UK system. It aligns with a wider government campaign to create what is being described as a zero-tolerance culture towards immigration non-compliance. Those caught more than once could face accelerated removal orders without multiple layers of appeal. Additionally, re-entry bans could extend from 5 to 10 years, depending on the severity and frequency of the offence. The policy also targets networks that assist in document fraud or unlawful recruitment, with stricter penalties for employers and agents who repeatedly employ migrants without valid work permission. Authorities are investing in new biometric tracking tools and data sharing agreements with partner agencies across Europe to improve border monitoring and enforcement outcomes. For foreign residents or workers in the UK, the message is clear. repeated violations will no longer be tolerated. Anyone who has previously breached immigration rules should take proactive steps to rectify their status or resolve outstanding legal issues before enforcement actions intensify. Seeking professional advice to regularize documents, repay unpaid taxes, or correct prior errors could prevent removal. The 2025 framework represents a turning point in how the UK distinguishes between one-time offenders and habitual violators. Those who repeatedly disregard immigration laws may now find themselves permanently barred from returning, reflecting a government determined to restore control over its borders. Number 5. Nationals of countries that refuse to accept returns. The UK government has made it clear that from November 2025, nationals of countries that refuse to accept their deported citizens will face tougher measures. This rule targets individuals whose home governments delay or deny travel documents required for deportation. Under the new policy, the UK will use visa restrictions and diplomatic pressure against countries that fail to cooperate with return agreements. This means people from those nations could face higher deportation risks, stricter visa issuance, or complete travel bans. Officials have identified this as one of the biggest barriers to enforcing immigration laws, with many deportations delayed because countries refuse to confirm identity or issue passports for return. The reform introduces a reciprocal responsibility model. If a foreign government does not help the UK remove its citizens, nationals from that country will find it harder to live, work, or study in Britain. The Home Office plans to publish cooperation scorecards for each country to measure compliance levels publicly. This measure aims to push global accountability while protecting UK taxpayers from funding repeated failed deportation attempts. Countries that consistently refuse to cooperate may see reduced visa quotas, suspended bilateral agreements, or targeted sanctions. On the other hand, nations that collaborate on returns may benefit from faster visa processing and improved diplomatic relations. The new approach reflects the UK's frustration with ongoing deportation barriers, particularly concerning individuals from countries that have repeatedly ignored repatriation requests. These cases often lead to prolonged detention, costing the government millions annually. By enforcing this rule, authorities intend to ensure that every deportation order results in actual removal rather than indefinite administrative delay. For individuals affected by this, awareness and preparation are crucial. If your home country has a history of non-cooperation with UK deportations, it may now impact your immigration outcome directly. Those awaiting asylum or visa decisions could be treated as higher-risk applicants. Seeking professional legal advice and understanding your country's current cooperation status can help you plan accordingly. The UK's message is firm. Residency is a privilege tied to international accountability. By linking immigration policy to diplomatic cooperation, Britain is signalling a new era of enforcement, where every nation must share responsibility for its citizens abroad. Number 4. Asylum seekers whose claims are rejected. Under the Border Security, Asylum and Immigration Bill 2025, asylum seekers whose claims are refused will face rapid deportation from the United Kingdom. The new system introduces a streamlined process that limits repeated appeals and shortens the waiting period after a final decision. The government's justification is that failed asylum seekers often stay in the UK for years while lodging multiple appeals, many of which are eventually dismissed. To address this, the Home Office will now prioritise removal within days or weeks after a claim rejection. The policy also includes agreements with safe third countries, allowing the UK to deport individuals to nations deemed safe, even if it is not their country of origin. This policy shift is expected to significantly increase deportations and reduce what officials call the backlog of unfounded asylum cases. The government insists that this reform is necessary to protect resources for genuine refugees while deterring false or abusive claims. Human rights organisations, however, warn that the fast-track removal system could endanger vulnerable individuals whose cases require deeper review. Critics argue that some asylum seekers flee violence or persecution, but struggle to provide evidence quickly due to trauma or lack of documentation. With shorter deadlines and limited access to legal advice in detention, the risk of wrongful deportation rises. Deportation flights to countries with questionable human rights records have already sparked controversy, with campaigners calling for independent oversight. Nonetheless, authorities maintain that every case will still receive a fair initial assessment and that deportations will target only those whose claims are clearly without merit. This balance between humanitarian duty and border control remains at the centre of national debate. For asylum seekers currently awaiting decisions, it is crucial to prepare comprehensive and well-documented claims from the beginning. Gathering medical reports, witness statements, and country evidence early can make the difference between protection and removal. Legal aid groups advise applicants to stay in close contact with their solicitors and avoid missing any communication from the Home Office. The new law leaves little room for delay or error. Once a claim is refused, deportation may happen faster than ever before, marking a decisive and uncompromising change in the UK's asylum policy. Number 3. People overstaying visas or living without legal status. Those who have overstayed their visas or are living in the UK without valid immigration status will be among the most affected under the November 2025 deportation laws. The government has confirmed that overstayers will face stricter enforcement actions, including detention and removal within shorter timeframes. This step is part of the wider national strategy to discourage illegal residents and restore confidence in the immigration system. Individuals who entered on student, work, or visitor visas but failed to extend or switch their status before expiry are at high risk of deportation. The Home Office now uses advanced digital tracking and biometric systems to identify expired visas faster than ever before. Under the new framework, warnings or grace periods that once allowed late renewal may no longer apply. People staying unlawfully will be marked as removal priority, meaning they could be detained with little notice. Authorities claim the rule aims to protect lawful migrants and ensure fairness to those who follow proper procedures. The reforms target what the government calls a culture of non-compliance, where people stay after their visa expiration, assuming enforcement will be slow. To close this gap, immigration officers are being given broader powers to conduct residence checks, workplace raids, and data-based follow-ups. This means landlords, employers, and even educational institutions will play a stronger role in reporting suspected overstayers. The policy also links directly with financial institutions, restricting access to bank accounts, rental agreements, and public services for anyone found to be without lawful status. Once identified, such individuals will be issued with removal directions, often within weeks, and could be banned from re-entry for several years. For migrants currently in the UK, this new environment demands immediate legal awareness. Anyone whose visa has expired or is close to expiring should seek professional immigration advice to regularise their status before enforcement begins. Ignoring letters from the Home Office or assuming leniency could now have serious consequences. The 2025 reforms mark one of the toughest crackdowns on overstayers in UK history. The message is clear: maintain lawful status or prepare to face deportation. With enforcement becoming faster and more technologically driven, those acting early stand the best chance of protecting their future in the United Kingdom. Number 2. Individuals whose human rights claims are refused. Under the new UK deportation framework, individuals whose human rights claims are denied will now face removal before their appeal is heard. This marks a major departure from the previous system, where people could remain in the UK for months or even years while appealing their cases. The 2025 policy, often described as the remove first, appeal later model, aims to speed up deportations and prevent what the Home Office calls system abuse. The government argues that many refused applicants have used the appeal process merely as a delay tactic to stay in the country longer. Once their claim is officially rejected, they can now be deported immediately and will have to continue their appeal process from abroad, often with limited access to local legal support or family assistance. This structural shift could affect thousands of migrants, asylum seekers, and overstayers who depend on human rights protection as their last legal defence. Officials say this policy will restore the integrity of the UK immigration system by reducing the number of people exploiting appeal rights to avoid removal. Critics, however, argue that it undermines fair hearing principles, since appealing from another country may restrict access to legal counsel and evidence. Many human rights organisations have expressed concern that deporting individuals before a full appeal decision could lead to wrongful removals, especially in cases involving humanitarian protection or fear of persecution. Yet, the government insists safeguards are in place for vulnerable applicants and that only clear-cut refusals will qualify for immediate deportation. Immigration lawyers warn that this rule will likely trigger a surge in last-minute judicial reviews as applicants race to stop removal orders before their flights. For individuals affected by this policy, it's vital to act quickly once a refusal notice arrives. Seeking expert legal representation can make a significant difference in identifying appeal options or new grounds for protection. Staying informed about your application status and maintaining open communication with your solicitor is essential, as delays could lead to sudden deportation. The government's message is direct. Once your human rights claim is rejected, your stay in the UK may end immediately. The burden now lies heavily on migrants to prepare stronger initial applications and ensure every piece of supporting evidence is ready from the start. Number 1. Foreign nationals convicted of serious crimes. Foreign nationals who have been convicted of serious crimes in the UK will face immediate deportation under the new November 2025 rules. The government has tightened its immigration laws to ensure that any non-British citizen who poses a risk to public safety is removed from the country without lengthy appeals or delays. This policy applies to individuals convicted of offences such as drug trafficking, assault, fraud, and gang-related activities. Even those who receive shorter sentences can be deported if their actions are deemed to violate the UK's public interest or national security laws. The Home Office plans to expand its automatic deportation framework to cover more offence categories, which means the margin for leniency will be greatly reduced after the new law takes effect. This move signals a firm stance against those who break the law while living under the UK's protection. The policy is designed to speed up the removal process through a revised removal window, allowing officials to deport individuals within days after their sentence ends. Previously, the appeal system and human rights claims often delayed deportations for months or even years. Under the new structure, such appeals can be handled while the person is outside the country. This change is expected to reduce the burden on UK courts and detention centres and send a clear message to foreign offenders that they cannot use legal loopholes to remain in the UK. Authorities have also announced closer coordination with foreign governments to ensure the return of deported citizens to their home countries. Special focus will be on countries that have previously refused to take back their nationals. For foreign residents in the UK, this rule serves as a powerful reminder to follow local laws strictly and maintain a clean record. Those convicted of any crime should immediately seek immigration legal assistance to understand their rights and possible defences before removal proceedings begin. The UK government has made it clear that its priority is the safety of citizens and the protection of its borders. Public reaction has been mixed, some supporting the move as a deterrent to crime, others criticising it as a harsh measure that may affect families. Regardless, this policy marks a defining shift in how the UK handles criminal non-nationals and sets a strong precedent for future immigration enforcement. The November 2025 deportation laws mark a turning point in the UK's immigration system. Strict, fast, and uncompromising. From overstayers and visa violators to rejected asylum seekers and foreign offenders, every category now faces sharper scrutiny. The government's message is unmistakable. Only those who follow the law, meet conditions, and contribute positively will be allowed to stay. For thousands, these new measures could mean forced departure, family separation, or permanent bans from re-entry. Yet for others, it signals fairness, safety, and a system finally holding everyone accountable. This is not just an immigration reform, it's a complete reset of national policy and public expectation. If you live in the UK on a visa, now is the time to review your status, seek legal advice, and ensure every document and condition is fully compliant. Staying informed could be the difference between security and sudden removal. If you found this breakdown helpful, like this video, subscribe for more updates on UK immigration changes, and comment below your thoughts or experiences. Stay ahead, stay aware, and protect your right to remain in the United Kingdom before these new rules take effect.